Hello. Welcome to our weekly COVID updates for employers and foreign workers. Today, we hope to take a deeper dive into some of the discussions that we've had in the past. And, let me know if we're having thunderstorms here, so any issues with hearing me, just send me a quick message, through chat, and I'll make sure I speak louder. Whoops. Somebody said good morning and thank you for scheduling this. No, we look forward to helping you navigate through this very difficult time that we're all having. Some issues that relate to your immigration and how they can, impact your status. So good morning to everyone. And so first, let us recap what we talked about last week. Last week, we talked about the updates for F1s, J1s, H1Bs, H2Bs, and the USCIS changes in processes relating to, the EIDI extensions and office closures. You are able to find all of this on our YouTube channel. Please look at that if you need a recap or if you were unable to attend the meeting last week. And subscribe to our YouTube channel. We plan to have a lot more information where I'll be talking about issues relating to remote work in depth. So here we're able to talk about the overriding general issues, but for the specialized issues that we're going to post on our YouTube channel, we'll be taking a deep dive into everything from permanent residence to, how to start your own business as an immigrant to, permanent residence options and a bunch of other things. So please subscribe so that you can avail yourself of all that information. And look at the YouTube channel to either re-listen to or catch up from last week's webinar. This week we talked about what the updates were with regard to immigration on the various status issues. But we thought it would be a good idea to kind of take a deeper dive and talk about what the rules are and how they can help you, especially given, the current changes. So for F1 students, typically everybody knows that initially you are granted 12 months of optional practical training for regular OPT. STEM OPTs get some additional time. And the key is it's got to be related into your major area of study. Some of the things that you can look into are, I know a lot of people are struggling with trying to find a job, especially given the current economic environment. And we're going to talk about, maybe what are the things that you can do in this time. But first, it's important to understand what the regulations are, and then we can get into what is it that you can do. So it's up to 12 months, STEM OPT. I'm sorry, a regular OPT, and STEM OPT is another 24 months. And it's got to be related into your major area of study. That's critical. So how do you go about doing this? Well, the OPT process is pretty straightforward. You have to request OPT from your designated school official who will annotate your I-20. You have to apply within 30 days of the DSO, the designated school official, entering it into SEVIS, and you can apply up to 90 days before. Now, even if your school is closed, most offices are still assisting students with their OPT. So talk to your school typically what they're doing is they're mailing it in, and with the signatures and everything else, instead of doing it in person, to respect the social distancing. And you can apply no later than 60 days after completing your degree. What happens if you don't find a job? Well, as you know, sorry, let me go back to that slide for a second. As you know, you have only a specific amount of time where you can be unemployed during OPT, and you have to find a job. So one of the things that you can do is perhaps start your own job. Under OPT, not STEM OPT, but regular OPT, you are able to start a business. And some of the things that you can do to start a business is maybe set up a consultancy. And so you can work for yourself. And that may be an option for a lot of you who are finding trouble finding a job. And that's as long as it's in the area of your major field of study, that is an option you can leverage so you don't fall into the issue of being unemployed and thereby breaching your status. Because remember that that the employer is not required when you are filing for OPT, but unemployment up to 90 days is allowed for regular OPT and 150 days for STEM. So you want to make sure you maintain your status. And so if you can't find an employer, you can set up a consultancy. You can do things to start your business. Put together a business plan. All these things are permissible under the OPT guidelines. So that may be something that you want to look into. And the reason why you want to do that is, you want to maintain status. There's a difference between maintaining status and unlawful presence. So unlawful presence means that there are the bars. There's a 3-year bar and there's a 10-year bar. If you were unlawfully present in the United States for a certain statutory period. Now, the good thing is that the bad news was the USCIS had tried to, through policy, change their long-standing USCIS policy on unlawful presence. So for students, remember when you come into the United States, your I-94 is stamped not with an end date, but it's stamped DS, meaning duration of status. So the only way a student typically could accrue unlawful presence is not because of a status violation. They could accrue unlawful presence because an adjudication by a USCIS. So if you filed for an H-1B and your H-1B was denied, that would be an adjudication by either the USCIS or a judge. So in those two situations, you could accrue unlawful presence. That doesn't mean you were lawfully present in the United States, though. So the unlawful presence is focused, excuse me, on triggering the bars. 3-year and 10-year bar for entry, okay? That's unlawful presence. And like I said, right now, the only way an F1 student can accrue unlawful presence is if it's adjudicated by a judge or the USCIS. Maintaining status is needed if you want to change status to a non-immigrant application or for permanent residency in the United States. So it is equally important, but it's important to understand the distinction between the two. So if you're unemployed for greater than 90 days, then the issue could be that you would be not maintaining status, and you would have a problem down the road, changing status to an H-1B. Now, remember, you have to notify your DSO within 10 days of termination or any change in employment. So the onus is on the student to inform the DSO, but like I said, one of the options is starting your own business during this time, you know, getting onto the entrepreneur spirit during OPT. And, you know, maybe enrolling in another academic program would be two options that you would be able to avail. Now, and if you've got any questions on this, email us either, you know, ask it now, or if you've got something in depth, email us at info@challalaw.com. And later this week, and we will be announcing it, I'll have a guest on here who can take a deep dive into the SBA loans and talk a little bit about franchises and businesses if you're looking to start something like that up. And then we're also going to address perhaps the E2 visa for students. And E2 visas are treaty-based visas. And although not all countries have a E2 treaty with the United States, there are some countries that give you citizenship within a year if you invest some money in that country. And so if you do that now, within a year, you may be eligible for an E2. So those are some of the things that will be coming up in, and we will let you all know when we schedule that seminar. So can you please talk a little bit more about starting a business or consultancy by F1 during OPT? Yes, the regulations for OPT clearly permit starting your own business. So during that time, what you can do is you can create a business plan, set up you would set up an entity, a formal corporate entity, and you know, create a business plan. You can meet with possible individuals to, you know, grow your business. And there are options that, you know, in a very limited capacity that H1 can be sponsored by their own company. So you could even try to, coming up next April, file an H1B on behalf of your company. But, you know, we have a memo on that and we'd be happy to send it to you. So email us at info@challalaw.com and we can send you that information. Or like I said, we're going to be having a special webinar just on setting up your own business and what some options are, you know, for entrepreneurship within immigration. So CapGap, sorry. Once you file an H-1B, the time, if you timely file an H-1B before the, you know, before the expiration of your OPT status, your OPT, let's say you filed in April, there's no premium, it's pending. Your OPT expires on June 1st. As long as you file a timely change of status application, while it's pending, and if it is approved, then you didn't, you know, you're able to continue working. I have two questions. So my STEM OPT expires on June 2020, and I didn't get through the lottery this year, last attempt. Due to COVID, is there any provision to extend our STEM OPT further so I can stay in the US and support myself financially? Unfortunately, not as of this date. Both NAFSA and American Immigration Lawyers Association is lobbying Congress and the USCIS to put in those provisions, but as of now, it's not there. And the second question is, now H-1B premium processing is canceled. Can an H-1B stay if a labor is approved for an extension and the case has been filed with the USCIS for an H-1B extension? Yes, you are allowed to stay in the United States. You can only work 240 days during that period, and that's pursuant to the I-9 regulations. So while your extension is pending, oops, you can, you're eligible to, continue to work in the United States for 240 days. So if your H-1B wasn't selected for, the cap, what are your options? They're not a lot, but one of them is, for some nationals, like I said, if you qualify for an E2, maybe transferring to, changing status to an E2 may be an option. You can transfer to another academic program. And one of the things I want to highlight, though, is if you transfer to the same level program, you've graduated a master's program, you're going to enroll in another master's program, there can be some tricky issues that come up when you file for your H-1B. We have seen that the USCIS issues requests for evidence on two issues. Number one, because the regulations state that you can't have, if you're in the same academic program, you can only have a total of 12 months CPT and OPT combined. So the issue becomes when you are filing for the same level and you obtain an OPT from, CPT from day one, because typically you have to wait 6 months to enroll in a CPT program. Now, the way we've been able to overcome that is by heavy documentation. Number one, make sure in advance you get a letter from the school that states that their program mandates, that requires CPT immediately. Number two, try to make sure that you document how you've gone to class, or maybe how this new master's really enhances your previous master's. So, for example, if you have a degree in product design, maybe you want to get another master's in something more technical because you want to do UX. And even though there are no formal classes, but maybe there's some certain type of technologies that would enhance your ability to, do that work. Keep copies of the transcripts, proof that you did go to class. And in other words, think of it this way, that you're not using the second master's as a way to work, okay? Because that's what they don't want. They don't want you to use the master's degree program to circumvent your inability to get an H-1B. So if you can document the validity of the second master's and how it's mandated that, how it's mandated that you are required to do a CPT, then I think when you file for an H-1B, and if an RFE should come up, you may be able to somehow defend why you have gotten the degree in the same level. Now, if you, again, let's say you're in you've taken you've got a master's degree in a non-STEM program. Another way to do this is to try to get a PhD in a STEM program. Because if you get a PhD in a STEM program, not only would you be able to, even if you've already gotten a STEM degree, if you progress to a higher level degree in a STEM program, you are afforded the additional 3 years for not only your regular OPT, but STEM OPT. And although I'm sure many of us are not crazy about, trying to do something as difficult as PhD, that may be a good option for you to leverage an additional 3 years on your OPT, and, look into the different PhD programs. They are, nowadays they're really, institutions are becoming very creative in the way these programs are running. And especially if you're an entrepreneur, they have multidisciplinary, programs that would really, I think, be a benefit down the road for you. So not only would you be able to avail yourself of the OPT, but you are securing a degree that could possibly help you in your profession down the road, which I think is critical. Returning to your home country. If you plan to return to your home country, you know, they have not outlined, you know, if you weren't selected and you're on OPT, there are issues of your, you know, ability to come back, typically. Now, if you are continuing in an academic program and you're traveling, you are able to take your online classes overseas. And they've now got a flexible rule that, you know, typically if you're outside the country for more than 5 months, SEVIS terminates your information in your in their system. But SEVP has flexibility on that, so you'll be able to stay outside the US for more than a 5-month period. You need to carry travel documentation and be prepared that there may be a problem re-entering the US. That's always the case when you travel outside. So I personally don't recommend it, but there's some people that don't have an option otherwise. I was selected for the CAP, but what should I do? I'm concerned I will lose my job. Well, remember, you've got 90 days unemployment on OPT, but you can become an entrepreneur, as we talked earlier. You can change your status to a visitor visa, you know, in the interim, because if you are here in the United States, you weren't selected for the H-1B CAP, and your OPT is going to expire, let's say, in May. Well, you've got the 60 days grace period on the OPT. And if you can, you know, if you're not going to enter into another academic program or that's not feasible, but you're unable to travel back to your home country, given the travel restrictions, then you can change your status to B1, B2. Now, I spoke about this last week. If you are selected for the H-1B CAP, okay, and your petition is approved, the effective date for that is going to be October 1st. In the interim, if your employer terminates the offer of employment, that H-1B has vested with you. And it's okay that you're not working for them yet because it doesn't start till October 1st. So, you know, you still, if you're on OPT, you still have to adhere to that 90-day unemployment issue, that you can't be unemployed for more than 90 days. But you can always transfer your H-1B employment to a new H-1B employer between now and October 1st. So that is something, like I said, it vests with you. That is something you're able to do. So let me see, I think there is a question. Trying to minimize this. There we go. Okay, here's a couple of questions. I've exhausted my OPT and STEM OPT. Am I still eligible to go on CPT? If yes, how long? The second question was, do I need a job offer before I join a day one CPT program? Two things. One is, if you've already, remember the issues that I had brought up earlier about day one CPT. You know, the school has to show that it is part of the requirement for the academic curriculum. Now, most academic institutions will require that you have a job offer before they give you a CPT, endorse your I-21 CPT. So that would be yes. And if you do go on CPT for day one, like I said, you have to prove, not now, but when you file for an H-1B, that's when this problem is going to be highlighted. You would have to prove that the academic institution or academic program mandates that you get CPT on day one. Number two, they want to see that you are taking these classes legitimately and you're not just entering into an academic program for the CPT. So you want to talk about the curriculum, how it enhances your current academic degree, and some of the other things that we talked about earlier. So Yes, you can do that, but you know, there is that challenge. I think there's somebody. The question is, if I file a change of status to H1 to B2 before the I-94 expiration and then leave the USCIS before the C change of status decision after the I-94 expiration, do I accrue unlawful presence for the period between the I-94 expiration and my day of departure? That is a good question. And here is the regulations state that unlawful presence is typically accrued from the date of your I-94 expiration. If you file a bona fide change of status application, you're not in a valid status at that time. You are in a period authorized by the Attorney General. Now, years past, as long as that was pending, you would be tolling your unlawful presence. Now, if the petition is denied, if the change of status is denied, that's when your unlawful presence starts ticking. I don't know what we're not very clear with this administration and how they, you know, how much discretion that they afford people on things like that. I mean, we have seen adjudications with adjustments and others where they have shown that they don't deem the longstanding policy that you are in a status authorized by the Attorney General. But here's the thing, as long as your stay, your I-94 expiration, you don't stay in the United States for more than 180 days after that, let's say you stay a couple of months, I would take, on your reentry to the US, I would bring proof that you filed a valid change of status, that it was receipted by the USCIS, so you need the receipt notice, that you didn't violate your status in any other way, and that you left the United States before it was adjudicated because of long adjudicative trends. So the issue is going to come on your reentry. So when they look in their database, you want to be able to present to them that you did file a bona fide change of status, and therefore you were in a status authorized by the Attorney General of the United States. So H-1B updates. Now we talked about this, taking a, like I said, a bit of a deeper dive into termination and leave options. You can take personal leave. Personal leave is permitted under the H-1B regulations. The CARES Act extends family and sick leave for COVID-19 layoffs. So, you know, look into that and see if you can leverage some additional leave as a result of that. You can also transfer your H-1B to a new employment. And you can start working, I know with premium processing suspended, you are permitted to start working as long as the petition is received by the USCIS. So that can be, you know, there's no clear regulations as what does that mean it's received by the USCIS. There are some employers that, and some individuals that are willing to take the risk, and as soon as they get a FedEx confirmation, start their employment with a new employer. There are others that would rather wait for the actual receipt notice, which can take up to 6 weeks before they start with a new employer. But that is something that you can think about if you think that there may be, you know, you may be terminated. Unlawful presence. Unlawful presence accrues for H-1Bs at status once their status is no longer, they're no longer to be maintained. So it's once the employment ends plus the applicable grace period. You can depart the country, you can switch to another immigration status to avoid triggering the unlawful presence. You can leverage the, you know, if you are still in valid status and your employment ends and your expiration of your H-1B is greater than, you know, 60 days, then you can have that, you can leverage a 60-day grace period. If it's less than 60 days, it is only till the end of your H-1B expiration. It's whatever is first. The 3-year bar to entry is triggered by, when you're no longer to maintain status, but you got 180 days. So within that 180 days, if you depart or switch to another immigration status, okay, let's talk about departure. Departure should not be a problem because you would do it within the 180-day period. And so you'd be able to re-enter. If you switch employment, so your employment ends, you're past the 60-day grace period, but you're not at the 180 days, and you change employers, you can file for change of employment, but you probably won't get the change of status in the United States. That means they won't approve it with the I-94 at the bottom, because when the USCIS adjudicates a petition, when they review it, they do 2 things. One is they review your eligibility. Are you eligible for the H-1B? Is this H-1B employment? The substantive issues. The second thing is they will grant you an extension or an amendment of status and issue a new I-94 card. So those are 2 things. The second thing, though, requires that you have, because it's deemed a benefit, you have to be maintaining status in order to be able to do that. So that's something to think about, at least in terms of strategies. You can file for change for new employment, but I would do it for consular processing, especially now because of the premium processing period. And the reason why you want to be able to be very concerned about not accruing too much unlawful presence is, like I said, up to 180 days. After that, there would be a 3-year bar to re-entry to the United States. More than a year of unlawful presence, there's a 10-year bar. Unemployment benefits vary state to state. If you are on, the 60-day grace period for the H-1B, you would be able to obtain unemployment benefits. There are, short-time compensation for reduced hours. So look into the CARES Act. There may be things that you can leverage. And as we talked about last week, these would not be deemed a public benefit bar. But you have to be able to, like I said, make sure that you are complying with your status requirements. So just because you may have unemployment benefits extended for another 13 weeks, if that's going to be outside your grace period, then that could be problematic if you leverage that. So unemployment benefits are earned benefits because you remember you pay into it through each paycheck, so it's not public charge. Stimulus funds cannot be paid to individuals who are using the individual identification, ITN. It could be available for H-4 EAD visa holders and others with a Social Security card. Not available if you file taxes jointly with an H-1B spouse or taxpayer using a temporary identification number. So that's something to look out for. SBA business issues. Employers with a small business, sole proprietors, or independent contractors are eligible. It's eligible for nonprofits and faith-based. So that's something to think about, and maybe even talk to your employer about if that's a concern that he has. Paycheck Protection Program, PPP loans, is something that employers can leverage. It must be originated and closed by June 30th. Loans cover payroll costs, rent, mortgage, utilities, includes employee vacation, parental, family, medical leave, sick leave. It can't be used in conjunction with the tax credits for COVID-related sick and family leave. Can an immigrant-owned business utilize the PPP program? And it's not prohibited by the text of the CARES Act, which just says that you've got to have less than 500 employees and you have to be a US-based company. So that's the only requirement that it outlines in the text of the act itself. But the application instructions, because that was a change from what they were saying previously. So the application instructions say that if 20% or more is owned by an individual who is not a legal permanent resident or a US citizen, the PPP is denied. So I would talk to your bank to see, what they advise on whether you should apply for PPP. Loan forgiveness, if you keep the workers on payroll for 8 weeks, no collateral or personal guarantees are required. The maturity of the loan is 2 years at the interest rate of 1%. Payments deferred for about 6 months. 75% of the forgiven amount must be used for payroll. Forgiveness is reduced if the head count declines or if salaries or wages decrease. But this is a great opportunity for those employers that are struggling and trying to figure out, especially if you've got H-1B employees, how to continue maintaining, their payroll. The SBA the debt relief program will pay the principal and interest and fees and microloans for 6 months. So automatic deferrals for service, disaster, and business loans. So this is, again, a mechanism that your employer can leverage if that is if they are struggling to. What type of public charges are exempted for admissibility for H-1Bs? Well, unemployment benefits are specifically, like I said, they're earned benefits. The PPP loan is, we think, that you'd be eligible for most of this from the text of the act. But what we can do is, if you email us, we can send you a memo on the public charge memo, which may really help you, understand it in the, instead of what are eligible, it'll help you understand what is subject to public charge. So anything that is not listed, we can assume would not be subject to public charge. So email us at info@challalaw.com for a memo on public charge. Economic injury and disaster, up to $2 million in assistance. Loans can be used to pay fixed debts, payroll accounts, others. The interest rate is, pretty decent, 3.75%. They're long-term payments, no express prohibition for immigrant-owned businesses. So if you're not eligible for the PPP because you're an immigrant-owned business, then this may be something that you want to look into. Economic injury and disaster advance loan up to $10,000, available within 3 days, does not have to be repaid even if the economic injury and disaster advance loan is ultimately denied. Employee retention tax credit, refundable tax credit to 50% of the wages paid to the employees between March 12th and December 31st, maximum credit of $5,000 per employee. You can't use both the tax credit and the PPP loan benefit. Cannot be used for the same payments made to the employee under the Families First Coronavirus Response Act. So, but there are a lot of options. Delayed employee payroll taxes, employers pay 6.2% on Social Security on wages. So the CARES Act allow delayed payments 50% by December 31st, 2020, 50% by December 31st, 2022. Not eligible if loans are forgiven under the CARES Act. So that's another option. You weren't eligible for the PPP loan, but here's another option for the employers that are having issues. So I think let me check and make sure, because I'm getting questions on chat and the Q&A. Can we expect the U.S. We're looking. Somebody asked if there is going to be any changes with the extending the grace period for unemployment for H-1Bs greater than 60 days. You know, probably not, but we are checking on that. And like I said, there are groups that are lobbying for that. And I'll tell you why, because the unemployment rate is so high. But it's, you know, the idea is what we're trying to tell the federal government is it's not apples to apples. So just because the unemployment rate is so high, you also have to take into consideration the skills gap. And so this is critical because employers would be negatively impacted if they don't have people with the correct skills to do the work. So keep posted, you know, subscribe to our YouTube channel, sign up for our newsletter to get the latest, but we are keeping an eye on this. My I-140 is approved with employer A. On that approval, I have moved to employer B. Employer B has not started the perm process yet. Now can I apply for an H-1B extension with employer B with the I-140 approved? Yes, you can. You can apply for, especially, so the way this extension works, there are two ways to get an extension beyond your 6 years on an H-1B. One, if your perm and I-140 have been pending for more than 1 year. So let's say your perm goes into audit. You know, after a 1 year time period, you can apply for an extension, a 1 year extension based on the fact that your perm is into audit. If your I-140 is approved, but you are in a country that's oversubscribed, so you're not able to adjust status because there's not an available visa number, then you are able to obtain 3-year extensions until the available visa number is available. And you are able to change employment through that process. So that is something you can do. Okay, I've got a couple of questions on chat. Let me make sure I answer these questions. My I-94 expired while my H-1B extension was in place in normal processing. I received the extension denial after 270 days. Wow, the question moved. Of my I-94 extension. I left the US 285 days. Will there be any issues in reentry? So you filed a timely extension. So it expired while it was in place in normal processing. It ultimately was denied, but it was denied after, no, because you left 15 days after that. So the denial, the grace period would, your unlawful presence would be triggered by the date of the decision. So because you filed a timely application. So you shouldn't have any issues reentering the US. I would take proof of the receipt notice that you filed a timely extension, the date you received the denial, and the date of your departure. Let's see, the other question, we've got a lot of questions, so bear with me. Can traveling to India, you might have mentioned, can traveling this year to India risky because of COVID? Yeah, I mean, there's travel restrictions all in place everywhere. So I wouldn't say this year, I would say at this moment. I think you've got to keep track of what's going on and see, you know, when and at what point they open up embassies, especially if you've got to obtain a visa to re-enter. And I don't believe India is allowing people to, I think you know, restrictions are supposed to be lifted in 2 days, but I think there is some talk that they'll be extended in India. Thank you so much for, would possibly know if you have a presentation at H-2A and H-2B workers' rights under the new federal program. Stay safe and, well, take good care. If you could email us, we can send you information on the H-2B and H-2A workers and what the updates are. We covered that last week, so you may want to listen to that. Go back and listen to our YouTube on H2A, H2B workers that was last week, or send us an email. I would request that all of you, if you are enjoying our weekly webinars, please subscribe and sign up for our newsletter, and show us some love on social media. We would really appreciate that. And then the other question is, I have reduced work hours to 50%. If there's a system-wide work hour reduction, what are the procedures to do that? You will have to file, your employer will have to file an amended petition reflecting your reduced work hours. Otherwise, they're in violation of the wage and hour regulations. But the good thing is as long as once they file it, it doesn't have to be approved. You would at that time of the filing, you would be able to you would be able to leverage working part-time employment, but they have to file an amended petition in order to do that. And again, I think we talked about that in depth last week. So if you have not listened to it, go listen to our YouTube channel, and you'll be able to hear about the amended petition process and what's involved. Email us if we haven't answered. If you have any other questions, check back with us next week, where we'll take a deeper dive into another section of, the immigration regulations. Oh gosh, okay. If you've got any questions on the disaster relief, send us an email and we can send you some information on that. And what I would do is, because of, like I said, there's some ambiguity with the PPP, you may want to talk to your bank. And if you like, send me an email at info@challalaw.com. And we've got some banks that seem to be pretty conversant on what type of various reliefs are available, and who can benefit from that, as well as our materials. So we'd be happy to send that to you. Currently I have an LC approved for the H-1B employee. Do we ask them to post the original LCA posting at home or approved LCA? Okay. If you have an LCA if you have an LCA that is approved for a work site, but the employee is working from home, then they have to, if they're working from home, they can post at home. If they're working at the work site, they've got to post at the work site. There are some mechanisms by which you can do that. They are allowing, usually it has to be posted within the day the LCA is certified. They're giving a 30-day grace period to allow for posting. And you can do it if you have an intranet, if the company has an intranet system, they may be able to do it on the company system. If the employee is going to be working from home, you've got to file an amended LCA for the home employment. If it doesn't, if it's outside the MSA or commutable distance. Can we go to a visitor visa from an H-1B if we're furloughed? If yes, how long will it take for the process? And if the visa, we had discussed this earlier. You can change status to B1. The B1 processing time is really very long. And so, you're probably, that 180-day period, you want to depart before the 180-day period. But you can use that, especially if you are beyond if your status is still valid. That means your H-1B stay is still valid. And you want to file for that after your 60-day grace period. When should we receive an RFE from the USCIS? Is there a delay in that process? I would say that there is a delay in each one of the processes. They are allowing for additional time for, responding to the RFEs, but because there's no premium processing and they are short-staffed, we can expect delays. Are H-1B visa holders getting benefits from stimulus funds? Mainly the only ones really off the top of my head that I could think that you would be eligible for is perhaps the unemployment benefits during your 60-day grace period. I'm on a STEM OPT for which the EIDI expires in June. It can't be further extended. Am I eligible to receive funds from the government to stay in this country until the travel ban is lifted? There are, you know, if you look again at our last, you know, YouTube, we focused on 2 instances where if they're due to certain situations, the USCIS would allow F1s not only to, you know, stay in the United States, but perhaps get work authorization. And then I think I have answered all the questions. I believe, yes, I have answered all the questions so far for on both the chat and the question and answer. So if you have any additional questions, like I said, email us, subscribe to our YouTube, sign up for our newsletter, show us some love on social media, and we will continue to try to serve you every week, at least once a week with these, you know, our website, I mean, our webinars, but we may be adding some additional, you know, resources to our YouTube channel to address some of the specific questions and so what we're doing is we're taking your questions and then we're trying to take a deeper dive into that and putting up resources on our YouTube channel. And for businesses, we may have, we're looking into talking about entrepreneurship, and I may have some special guests come in and to talk about maybe some of the SBA loan issues, some of the things that you can leverage. We may have something on entrepreneurs and what OPTs can do, you know, to, you know, perhaps on their OPT, you know, buy a business, buy an existing business, apply for citizenship for a country that, you know, where you can probably get it fairly quickly, that is eligible for an E2 so they can change to E2 status down the road. So we've got some great YouTube resources and webinars up the pipeline. Stay safe, keep social distancing, and wishing you all a great week. This is Lakshmi Challa checking out. Look forward to talking to you next week. Goodbye.